That's all. I attempted to get better printouts of
The numbers.
and stuff, and they're just not legible. So I couldn't argue. Hey, she should have gotten $50,000 of child support. Who cares if she got let off $10,000 of debt?
Yeah.
Can't wipe this out. So my hands were tied. Yes. Motion to compel. I should compel the production of legible documents.
I think they're meeting them, I haven't done it before. Motion to correct.
The record, judge said. So, yeah, but I should. Burn out. Just came back from Hawaii. Yeah, and I got COVID. I had it the first time when they didn't have the shot yet. And I got the shot, and then I got the booster, and I got COVID when I got the booster. Did you have it bad? Tired.
Yeah.
My niece still can't smell and taste anything after 18 months.
From you.
Me too.
No, it wasn't.
Oh, I'm having to rebuild the record right now. They lost all the exhibits, and it's a mess. I have to rebuild the whole record. Not the whole record, the exhibits. I'm gonna have to do a notice of filing all the exhibits. And I already did a motion to supplement the record, explaining that this is basically you're looking for it. They haven't been able to find it, so I got my trial counsel to give me the exhibits, and they're nasty. Yeah, it was like a week trial, a week-long trial. But you know what really is a pain in practice law is when you get someone on the other side who's just not like one extension, like, oh, I have to object because my client wants me to object. And it's like, no, we don't have to object.
I cannot
They're gonna,
have a valid reason to object to a first or second or third extension.
Yeah.
I really can't. I mean, if someone's lazy, or using it to like.
or if their kids involved, maybe.
But like, in regular case, I can't.
Do you do stipulations?
Sometimes I do.
It's appropriate.
Most of the time, it's just a quick email. And then we just agree to have an extension, or we don't. It's usually what we do. And we have to attorneys, but if we have attorneys, that we can like. We get a stipulation, so we can.
Well, I never actually signed a stipulation, I just say that we stipulated. to
Oh,
an
yeah, I
extension.
did that, yeah. And if I agree to an extension, I'll see the problem.
Of course, yeah. It's just,
You've been burned before.
it's right here.
I had one attorney object. Well, he granted my extension. which is 14. So,
Oh, so you're doing trial for 2 or?
But I'm not. All you can see. Like, to work on as much as I can. So, Chris is really passionate. It's not even so always.
You're smart trying to get. That's all I did. I can do. I'll take a left off and get and keys and just have my. This. See, the reason she keep giving for modification, the reason that. Because judges, you know, all the time order a close range parenting plan when this happens.
Okay.
So judges do that all the time, even though there's like that perspective, you don't have the crystal ball. No, I mean, judges do it all the time.
Oh, okay.
They do it anyway. There's no case law because people go appeal it. Because it's what
It's
they
usually.
but, because you have to prove substantial change in circumstances and all these cases, which is gonna change the laws. But all the cases are like, apparently, it's not a substantial change in circumstances. So, oh, absolutely, I agree, but the case law says. No, the case law says. Yeah.
No, they have an issue to take care of to start. So we don't want nobody on deck. Correct. You get to experience something that you probably don't experience all the time.
Okay, all right.
What's up?
Crocheting to your glasses.
Okay, no issues.
Awesome.
Okay. Thank you.
I'm getting in trouble.
That makes me more nervous.
That makes me feel better. It's all for me.
So usually what happens is somebody doesn't submit according to what's supposed to be done, and they request it again, and it's not done, and they request it again, and it's not done, so now.
The oral argument?
No, like a brief.
No, yeah, so they requested an oral argument and they didn't.
No,
Yeah.
this is an attorney getting in trouble for not filing a brief or
Oh, I see.
something. And they've asked me to show copies.
Correct. This goes as high as the Florida bar, if that's what's deemed necessary. So,
I see.
so you'll be fine.
For them.
They take care of what they have to take care of, and then we'll move on with court. Yes. It doesn't set the tone for the rest of the day.
All I know is someone that said.
We don't have any.
Is the attorney here for show cause? Is the attorney here for show cause? She needs to come in now. All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Matthew C. Lucas, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated. She's just coming in the door now, so.
Good morning, everyone. Welcome to the Second District Court of Appeal. My name is Matt Lucas, and I'm pleased to be presiding today with my colleagues, Judge Drew Atkinson and Judge John Starger. We have a relatively short docket today. We'll attend to those in just a moment. First, we need to attend to a special set order in case number 2D22-250. Do we have attorney Leslie Federigos present?
Yes, Your Honor.
Ms. Federigos, if you
Sure.
please approach the well here. Morning.
Good morning.
Ms. Federigos, we're here on an order to show cause in case number 2D22-250. The way this works is I'm going to read to you an outline of what's happened in this case. And then we need to hear from you, the court does, about what's going on while we're having some either failure to communicate or failure to comply with court orders. So on January 21, 2022, you filed a timely notice of appeal in the case that I just referenced on behalf of a father. This is an appeal of the final judgment of termination of parental rights. On March 16, 2022, this court issued an order directing me to serve the court reporter with designations within 3 days. If you've not done so already, and forward a copy of this court in 7 days. I did not respond to that order. On May 2nd, 2022, this court followed up with an order directing you to respond to the March 16, 2022 order, or in the alternative, file a status report in this court within 7 days, stating that no designations would be filed in this appeal or risk sanctions. You did not respond to that order. On May 25th, 2022, one of our court staff members called your office and left a message with your answering service that advising you that you still have not complied with prior orders and informing you that sanctions could be imposed. We did not receive a call back in response to the call. On June 1st, 2022, this court issued an order requiring you to appear today at the oral argument session and show cause why you should not be sanctioned for the failure to respond to the March 16 and May 2 orders. The order to show cause did include a purge provision with a deadline of 1 p.m. on June 9 that would have allowed you to avoid having to come today. Unfortunately, you did not take advantage of that purge provision. You are here today to explain what's going on.
Yes, may I proceed?
Yes, ma'am.
Okay, in regards to the purge provision, I was in Jamaica for a week and a half, and I did not get, when you convert your phone, I guess internationally, I had no access to emails. And I got back on June 8th at midnight, because we traveled from Fort Lauderdale, and I have 4 kids, so I did not get to check my emails until after 1 o'clock on the 9th. Otherwise, I would have been happy to have complied with that provision, because I'm from Orlando, so I traveled here to be, to be here today. So that's why I didn't, take advantage of the purge provision, unfortunately. In regards to not addressing the previous orders, this particular case, I did not think would be successful with an appeal without transcripts. My client was back and forth between didn't know if he wanted to appeal, if he could afford to pay the transcript cost. I explained to him, that I wanted to.
Don't tell us what you discussed.
Okay, I'm sorry, I apologize. So the problem was I myself was left in the dark as far as if we were proceeding with the appeal, if he was going to get a hold of the transcripts, because that was part of the agreement that he was going to purchase those. He was going to provide me with those. I was doing this case pro bono to help, because it was a termination of parental rights. And I never got a straightforward answer. 1 week I was told, I can't say I'm sorry, but I'm just saying, so I didn't know quite how to respond. I didn't feel that the case would be successful in an appeal without the transcripts, because much of the appeal would have relied on testimony of some of the witnesses. I didn't think it would be successful without the transcripts. So if we could not get a hold of the transcripts, or he could not get a hold of the transcripts, I would have went ahead and he was aware of this, but I would have dismissed the appeal at that point, because I just don't think it would have been successful without it. But the reason that I have not, like I said, responded is really I did not know how to respond, whether I could give you guys a court reporter with transcripts, or I could not, so that was the reason for that. In regards to the phone call, I did switch over phone companies. I had an answering service, and then I ended up switching over to a program called Dial Pad. I changed it on the Florida Bar website, that phone number. But I had actually been operating probably for a good week or so before I did change it on the Florida Bar. But I did not, and I don't want to make an excuse, but I did not get that message, and had I would have definitely called. And I want to apologize to this court for even being here today and wasting this court's time on this issue. But that's really the only explanation I can give at this point.
Here's the problem. That puts us in an untenable position. This is a termination of parental rights proceeding. And I understand, all of us understand, we've all had clients who have vacillated on issues that pertain to cases. But under a termination of parental rights appeal, we are under a statutory deadline once that notice of appeal is filed to get things done. And there's an Anders process available to counsel if the case, in their view, is truly non-meritorious, such that they would be committing an ethical violation of continuing representation. You haven't availed yourself of that. At a certain point, you either need to be in or out, and you need to take the case that you can appeal and appeal it and write the best appeal you can, or don't. What's not an option is not following court directives and orders. What's not an option is not keeping us in the loop as to what's happening in this case. Let me reiterate the reason why this may sound somewhat petty, why we're bringing you in on scheduling issues, because this is a termination of parental rights case. The legislature has directed us to bump these ahead of everything else and treat them with the utmost seriousness and closest attention. And that's why, while I can appreciate the pro bono service on this case, while I can certainly understand going out on vacation, having to handle kids, Lord knows I can understand that. It really doesn't play into this. This case needs to move forward, or you need to get off of it.
Okay.
My colleagues and I, my colleagues may have some further things they wish to discuss with you. We're going to need to figure out what we're going to do with this case, though.
Yes, Your Honor.
No, I just second. Judge Lucas said it best. Time standards are there for a reason, and doing nothing is just not an option.
Okay. I understand, and I'm more than likely dismiss. I'm gonna call my client today so that this can be.
Again, you have to convey to us what you want to discuss with your client, but we need some kind of action.
Absolutely, I understand.
All right, thank you, ma'am.
Okay, thank you so much.
All right, we can now turn to a regular morning docket. Those of you who, I think most of y'all are familiar with how we do things, but just in case you're not, let me go over kind of the ground rules. We only have 2 cases set for today. We'll call them one at a time. When you hear your case, please, if you are the appellant, come up, introduce yourself. If you wish to, each side will have 20 minutes to present oral argument. If you are the appellant and you wish to preserve up to 5 minutes for rebuttal time, you may do so. Please just let me know so I can keep track of the timer. And with that, let's go ahead and call our first case, which is Nelson Hudson versus Hudson.
Good morning, Your Honors. My name is Allison Perry, and I represent the appellant Elizabeth Nelson Hudson, the former wife in this appeal. I would like to reserve 5 minutes for rebuttal, if I may.
Yes, ma'am.
I would first like to apologize to the court because in my brief, I stated that the former husband did not plead for majority time sharing, when on page 35 of the record on appeal, he did plead for it. However, at the beginning of the final hearing, his attorney stated that what the husband wanted was for the wife to move back with the kids and them to resume a 50-50 time sharing. And he also said at the end of the
But that would have been prospective if and when she moved back.
Well, she said she was gonna do everything in her powers to move back. I don't know how the court found that she had no intentions of moving back under this record.
Well, because the court made some credibility assessments, and you know, candidly, we've been there before where we hear a litigant saying, oh yeah, I want to do my best to do this. And maybe we don't, as triers of fact or even as attorneys, maybe we don't really buy that they're going to do their best or that they're actually going to follow through. Wasn't the trial court in a position to make that kind of call?
But the court said she stated she had no intention of moving back, but she did in fact state that she intended on moving back.
Going back to what I said before, sometimes we don't have to believe what people tell us, right? I mean, just because somebody says, yeah, I intend to do this as triers of fact, we don't have to take that as gospel, do we?
Well, that's a position that you can take, and the court can take, because they are the credibility determinator. So,
Well, didn't you say it won't be anytime soon? I mean, she made it clear it would not be immediately in that she.
well, she'd have to get housing.
So
yeah.
even if we may tinker with the trial court and its assessment, its ultimate assessment that she had no intention, can we say it's an abuse of discretion to have included in the order what was included pending a future change in her relocation?
Well, the reason that we wanted the close range parenting plan is because to show a substantial change in circumstances. If she moved for a modification instead of having it in there, you have to show a substantial change in circumstances. And there's all this case law out there that may become obsolete because of what's on the governor's desk right now. But it states, all the case law states that a parent moving is not considered a substantial change in circumstances. So she's in between a rock and a hard place because everyone knows or says she said she was going to try to move back. She was going to do everything in her power to move back. So it's something that's known at the time of the final judgment.
But to some extent, didn't she create the rock in the hard place?
Well, she created the rock in the hard place because her husband put her under a rock. Because he said he was ordered to pay all the housing bills for the wife.
There were other options that she could have.
She went on welfare. She got food stamps. She got the kids a Medicaid. She was bending on she was almost homeless. So she had to go to,
And we understand all that. We've read the record. There's no great actors. Nobody's going to leave here today with a commendation for the way they handled themselves. But you're talking about a rock in a hard place that she created by upping and moving, 4 or 5 states away without any notice when she was required to give notice.
Now, she didn't give notice, once again, bad behavior, but this is after 3 years or 2 years of the husband not paying the bills he was supposed to pay.
So we're supposed to start applying a 2 wrongs make a right standard?
That's a very good question, Your Honor, but I'm just saying that she got in the hard place because she was actually like under a rock when she was in Tampa. Because he was not abiding by the court order to pay the temporary housing and living expenses of the wife and the children. He didn't pay any child support during the 3 years of the litigation. He told the wife when she asked for help with diapers, go to a church organization. So basically, the bottom line is she wants a 50-50 time sharing schedule to be able to get that without having to go through a modification.
Well, let me ask you to kind of go beneath the bottom line, the double bottom line. She lives in West Virginia. She has no place in Florida. How is a trial judge even supposed to make that happen without uprooting kids from school at different points?
Well, the way I've seen it done in other cases is if the wife moves back within the area within the next 60 days, the parties will go to a 50-50 schedule. We'll resume the 50-50 schedule.
So what you're really asking then is an unequal, and I'm not sure I saw this in the briefing, but an unequal schedule that reflects the fact that one's in West Virginia, one's in Florida.
Yes,
But in the event wife carries through with her stated intention of coming to Florida, then it switches to 50-50.
exactly.
And it was an abuse of discretion for the court not to have entered that as a parenting plan.
Well, that's my argument.
Okay. Okay.
So, and then as far as the child support goes, there were 22 months that was not awarded of retroactive support. And part of the reason that the court didn't award the retroactive support was based on the wife's bad behavior. And you don't sanction children for their parents' bad behavior.
But it was made up in some other areas.
Well, they did an unequitable distribution, so.
Which, as you know, is hard to get.
It is hard to get, but child support should be separate and should be away from the equitable distribution issues. And the unequitable distribution was based on the husband's waste also, because he had a propensity to visit massage parlors. So the court found that that was marital waste and that she was entitled to an unequitable distribution. So, are there any other questions? I'll reserve my time. Thank you.
Your Honors, I'm Howell on behalf of the appellee. So I wanted to first start by addressing the only issue in appellant's brief that I believe could have some potential merit and why I believe that that still fails here today. And that would be the retroactive child support argument. So appellant's argument is that the retroactive child support should have been paid for the full time that the parties were separate instead of for the 13-month period that the court awarded. In the paragraph in the final judgment before the trial court addressed the retroactive child support, it did note that it struggled with the financial determinations because neither party was forthcoming with their financial information. So I think that both parties' conduct definitely contributed to the trial court's determination in this matter. But the issue with appellant's argument is that while the guidelines for ordinary child support in Florida are presumptively establish an amount for child support, the retroactive child support is left to the discretion of the judge. So there are some factors that the judge must consider in determining the amount and whether retroactive child support is appropriate. There are three under Florida statute 61.30. The first one is the party's income, whether that be actual or imputed by the court. The second one is all payments made by either party for the benefit of the children during the retroactive period. And the third one is whether a payment plan would be necessary to do the retroactive child support. I think here on an abuse of discretion standard, it's clear that the court went in detail through each of these factors that it was required to go through. So the appellant can't meet the burden of an abuse of discretion. The court considered all of these factors and found that the father's income was imputed to be $133,000, that the mother's gross actual income was $62,000 per year, that the mother pays the children's health insurance expenses, that the father owes the mother $1,200 for unreimbursed medical expenses, and that the trial court actually also set a specific payment plan so that the father could become current on his arrearage and child support. So each of those is those prongs A through C that the court determined pursuant to the statute. But the court didn't only consider those things because it's discretionary. The court considered the mother's bad faith relocation without notice to West Virginia, and also the unequal distribution in favor of the mother, which was that the father took on all of the debts and the mother got more money from, and the proceeds from the father's portion of the house went to her as well. And to address the argument that the children shouldn't be punished by, the parents' bad actions, I think we can all agree that that's a solid premise. But I don't think the children were punished in this case because the father does have majority time sharing in Florida, and so her childcare obligations are lessened significantly because the father is taking on roughly 75% of the children's, living and all that other stuff. So I would just state that the appellant has failed to show an abuse of discretion by the trial court. As to the lack of notice as to the majority time sharing, I think we already kind of addressed it. I would just say that just because he was willing to do 50-50 by the end, if she moved to Florida, doesn't negate that he pled for majority time sharing, and that was something that the parties could expect to be awarded in this case. So I would say there's no lack of notice, and on de novo review, no due process violation occurred. As to the actual time sharing, which was the substance of the time sharing award, which was majority, it's also an abuse of discretion standard, and the courts have said that the decision has to be affirmed unless no reasonable person would take the view adopted by the trial court as to what percentage of time sharing goes to which party. In this case, the court considered extensively what would be in the best interest of the children based on the dissolution proceedings, and also based on the children's lack of ability to adapt to life in West Virginia. The children didn't adjust well and had behavioral issues in school, threats of self-harm, and were being held back. So the court found it was in the best interest of the children that they live in Florida, where they were well adjusted and where they did have a stable home. And in moving to West Virginia, the wife took herself out of Florida, so it only made sense for the trial court to award majority time sharing to the parent in Florida, because it's in the best interest of the children to live in Florida. So I would repeat that the court didn't abuse its discretion in awarding the majority time sharing. And then finally, I touched on this in the brief a little, and your honors touched on it a little bit with the appellant, but the mother invited any of the errors that she now claims the trial court made with her behavior, and both parties had abhorrent behavior, I think, throughout the proceedings. But the things specifically that the mother is appealing, each decision that the trial court made, it factored at least in part the choices that the mother made. So she cannot now benefit from those choices on appeal. Does the court have any questions?
No, ma'am.
Thank you.
Thank you. There you go. Your full 5 minutes.
I just wanted to point out to the court that the 22 months that the mother did not receive child support, she was unemployed. So the husband was making $130,000 a year, and the wife was unemployed. She had been a stay-at-home mother by agreement of the parties. And he provided absolutely no support during the 22 months. And like I said, you cannot punish the mother because of her bad behavior by taking away child support. That's not appropriate. And then I'd also like to congratulate Megan for, this is her first oral argument.
Thank
Very
you.
well.
So, good job, Megan.
Thank you.
Thank you both. We'll go ahead and call the next case.
Thank you, Your Honor.
Next up, we have Hadley versus Mackey Law Group.
Runners, we have designations of what each of us are from a prior order. And so I want to make sure we're sitting in the right spot. I represent Jamie Snyder, and we were identified as an appellee cross appellant.
Okay.
The Mr.
I know there have been quite a few proceedings. Y'all can sit down.
I didn't know where to sit, so
Yeah,
I.
that's fine.
Okay.
If this is housekeeping. we can sit down.
Do you want to get?
Have you all discussed, because I see we have multiple attorneys, multiple parties here, have you all discussed how you're going to apportion time in terms of oral argument today?
Your Honor, I'm the appellant. I'm Ernest Marshall, attorney retired, appearing pro se. I'll be speaking on behalf of the appellant today. I'd like to reserve 5 minutes of my 20 minutes rebuttal.
Judge Lucas,
Yes.
mind if I ask
council question.
Of course.
You're not a party, am I correct?
Pardon me?
You're not a party, am I correct?
I'm one of the appellants. Mr. Brown, the decedent, was my client, Tom Brown Jr. He died suddenly because of COVID.
Were you made a party?
Pardon me?
I don't believe you were made a party to the action or the appeal. And you're also, in not being a party, if you were a party, you would represent yourself, but not being a member of the Florida Bar, you're not, I just want to warn you, you're not allowed to represent clients.
Is
Well,
your,
no, I'm appearing pro se, and I did with my.
On behalf of whom?
Pardon me?
On behalf of yourself, but if you're pro se, you have to be a party. Are you a party?
In the sense that I was the attorney for Mr. Brown.
You're not a party for the circuit court action or this appeal, am I correct?
Yes, I'm a party pro se because I'm appearing.
You appear on the briefs, but that doesn't make you a party.
Pardon me?
I know that you appeared on the briefs, but that doesn't make you a party.
Right, we initially filed the appeal. I did, and Mr. Brown, while he was alive, we co-appeared pro se because of the fact that I had retired for health reasons from the bar. And so from that standpoint, we were going through the appeal process and then he suddenly died. So that left me as the sole person appearing as a part of the appellant's brief pro se.
that's novel, to put it bluntly. What I would propose to do is to hear your oral argument, but understand, sir, that your appearance and your argument today is intertwined with, to some degree, the merits of that's going on in this appeal, and may not entitle you to actually even speak. If you still wish to be heard, and if you still wish to take the lead, or on behalf of well, whoever you're purporting to act on behalf of, the court will hear you today, but I want you to understand that that's not a determination that you are appropriately appearing in this oral argument. Do you understand what I'm telling you?
I'm following you, Your Honor. I
Okay.
practiced law for 50 years. In fact, I was sworn in by this court, graduated from Stetson
Sure.
in 1966. I've been here for a while.
Sure.
Uh,
But to Judge Atkinson's point, you are not currently a member of the Florida Bar.
Pardon me?
To Judge Atkinson's point, you are not currently a member of the
No,
Florida
I
Bar.
retired because of my health.
Okay.
I had a heart attack.
Well, we still need to figure out how we're going to go forward on this case. Are you proposing, who are you, sir?
Jorge Martinez for the appellee Mackey Group.
Okay. Usually we have appellants over here and appellees over here, and it looks like we're kind of mixing and matching. And to some degree that may make sense in terms of what's happening in this case. So you're here on behalf of Martin.
Yes, my name is Jorge Martinez.
Mr.
Yes.
Martinez, and you are on behalf of,
Mackey Group.
got it. And over here,
Eileen Griffin, and on behalf of Jamie Snyder Brown.
got it, okay. And
Good morning, Your Honor. Megan Serrano representing Derek J. Hadley, who's the personal representative for the estate of the former husband, Tom Brown.
all right. For purposes of this appeal, I've heard from you, sir. How are you all proposing to go forward in terms of presenting oral argument today?
Judge, I would only need 5 minutes. I am really kind of just peripherally involved in this because it affects property that my client owns in one undivided 1/2 interest.
And Mr. Ron?
I don't anticipate that I would need the full 15 minutes. I just want to be clear, Mr. Marshall does not represent the decedent's interest, the personal representative does. So I don't think it's appropriate to share time, even though they initially filed the brief together when the former husband was still alive.
I may get a little more generous with time than I ordinarily do, but I want everyone here to understand that is solely by virtue of the fact that this is a somewhat unique case. Ordinarily, I'm pretty strict about time, but we may extend a little extra time just to reflect what's going on here. Ms. Serrano would be okay with 15 minutes.
Yes, thank you.
And
Your
Mr.
Honor.
Martinez.
Thank you, Your Honor. I would, again, I mirror opposing counsel sentiment, I would object to his standing in this position. I think, initially the briefs were filed jointly, and only for that reason, I think they were permitted, because the former husband, Tom Brown, did have standing to submit and appeal this decision. But regardless, I don't anticipate using the full 15-20 minutes, so I don't mind going last, just so I can answer all of these issues together, because there is significant overlap in these few issues that I brought before the court today. Thank you.
All right, with that, we'll proceed in this way. We'll start with Mr. Marshall. Mr. Marshall, we're not going to do rebuttal time, so tell me, the court will hear what you have to say for now.
Right. Go ahead. Thank you. This case is an example I don't practice anymore. I want to thank the court for your indulgence and the opportunity to hear. It's a privilege always to come before this court because of what I explained earlier, how I became a lawyer. This appeal was filed by the decedent, Mr. Brown, who I had represented in this case from 2009 up until the time that I retired, and I could no longer represent him as an attorney. But we continued because there was a substantial amount of fees that had been generated that he owed because of this case. And when Mackey Law Firm, who's represented here, Martinez, is that, I said that right, Martinez, represents the firm. I had initially filed a petition for dissolution of marriage in 2009 on behalf of Mr. Brown. At that time, I informed Mr. Brown, the decedent, but because of my health, I was recovering from prostate cancer.
I was wondering that with the presiding judge can correct me if he disagrees. I just want to make sure you are your presentation is confined to what is in the record.
Yes, it's in the record, but
I just want to, I know, but I just want on the outset, since this unique situation, because the issue on appeal has to do with the representation provided by lawyers to the decedent, and whatever you were going to say about that, I needs to have been in the record. I just want to warn you about that.
I have to do what?
Whatever you say about what your representation of him was prior to the representation of the Mackey Group, which is at issue in this, may bear upon the resolution of the issue on appeal, which is whether the charging lien was correctly imposed. So please be careful not to include anything outside the record.
No, of course.
Okay.
I want to do that. What I'm trying to do is to explain my initially representation of Mr. Brown, the decedent, and then at the time I informed him because of my health that they would have to seek other counsel if it was not settled. I was attempting to settle the case on behalf of the decedent and former wife, and we were very close to this being accomplished. And suddenly, the case turned into a contested matter. And at that point, I informed them that because of my health, that they needed to bring on a law firm or a younger lawyer to handle it, to litigate it, because I wouldn't be able to do it. And after that, Mr. Mackey, Mr. Martinez, who represents the firm there, entered the case approximately right after the case got filed. We hadn't filed. And I was asked to stay on by the decedent as a counsel because of my experience in family law matters. And I agreed to do that. I stayed on, and Mr. Mackey stayed in the firm for approximately, I want to say 6-8 months, something in that neighborhood, from the beginning, and then withdrew from the case and left the decedent and myself as a counsel, trying to figure out what to do next. That was either he proceeded pro se, or I had to step back into the case at that point on a full-time basis to help him, or we had to try to find a lawyer. He didn't have any money because whatever money he had at that time, he had paid out a portion of it to me as a counsel. The majority of it to Mr. Mackey's law firm. And then Mr. Mackey withdrew. And from then on, I remained in the case to a point in time that I was disqualified by the case. The former wife, through her different lawyership, various lawyers, had attempted 3 times to disqualify me. And they finally succeeded on the other 2 that were dismissed. Inappropriate. So from that time on, the only thing remaining was I had a pending motion for attorney's fees and costs incurred by me representing Mr. Brown because he had no money, but we had a fee agreement and he agreed to pay it. And as a result of that, when the matter of Mr. Mackey's claim of lien, which is the subject of this order, is before the court, Judge Byrne down below, occurred, is that I was with Mr. Mackey, with Mr. Brown, while he was still alive, we were contesting the lien that Mr. Mackey's firm was attempting to enforce. And that's how I got involved in the case up to this point. When the lower court entered an order for the granting of a lien so that Mr. Mackey could continue with the foreclosure he started in Colorado to foreclose his lien without a judgment, he was attempting to get the judgment, did get a judgment from Judge Byrne, which is on appeal now to you, this court. He passed away, Mr. Brown did. The court in Colorado stayed the proceedings there because there was no judgment to go out there and enforce that lien with, and in fact sent it back here to Florida. That's when Mackey Law Firm went in and got a judgment, which resulted in what we believe an erroneous judgment, and it's on appeal at this time. And it's being appealed also by, as I understand, on the way. Now, the issue basically is very simple. Judge Brennan's order was articulated the principles and rule, the way to go about determining if there was sufficient proof to establish the right of Judge Brennan to enter that order. And it was incumbent upon the Mackey Law Firm to produce proof to show this in accordance with the rules of civil procedure.
Mr. Marshall, do you have a lien, an attorney charging lien on this property?
Pardon me?
Do you have a charging lien on this property?
Yes, I do.
Okay.
I have a charging lien, and I have a pending motion for attorney's fees and costs that's going to be heard in the family law court when we return from this appeal. We filed the claim of lien in this case in the estate, and the motion was pending for attorney's fees.
When did you present your claim of lien on this property? As I recall, it was before the entry of the final judgment dissolution. Yes, it was before. I was still a lawyer at that time. Mr. Brown, the decedent, and I filed a joint motion seeking attorney's fees and costs because that was our agreement and understanding. He didn't have any money to pay me, and I wasn't going to pay him. I didn't withdraw. I stayed with him in spite of it. It was pretty tough because I had health issues all the way through. Anyway, long story short, we went to the hearing, and Judge Brennan, because of the fact that I was no longer licensed, only allowed me to object to the proceedings because of the due process issues that were not being observed in conducting that hearing. It was a very short hearing. There was absolutely no proof introduced by the Mackey Law Firm to support that they either protected, preserved, or created the property that was at question. Assuming without deciding that you had some kind of standing below as a putative lien holder on the same property, what is the basis that you contend that the Florida Rules of Civil Procedure apply to a post-decretal procedure such as an attorney charging lien proceeding? There are no pleadings that are filed when a charging lien is adjudicated, correct?
I couldn't understand you. You have to excuse me, I have a hearing issue as well.
All right. There are no pleadings that typically get filed or served in connection with attorney charging lien claims, correct?
That's correct. The simply files the claim lien.
your argument, again, assuming without deciding that you had standing to bring it, your argument seems to be that the process required under the Florida Rules of Civil Procedure pertained to the procedure to adjudicate an attorney charging lien claim. Or am I mistaken?
No, they failed to follow the due process rules that require procedurally and substantively to establish their proof.
What are those rules?
Well, number one, that they have to show under the two cases that have been decided by this court, one by the fourth district, that you have to show that you have done something to cause the asset that the lien is being used to attach.
So let me take issue with, that's not a procedural failing. That sounds to me like an argument on the substance of the lien, whether or not, in fact, you've done anything to earn it. But that's not a due process failing. That's not a constitutional failure, is it?
It is when there was a failure of the lower court to allow discovery, the filing of responses to the claim when Mr. Brown, the decedent, was alive, to contest the fact that there was no.
That goes back to my earlier question and point, which is that attorney charging liens are usually post-equitable. They usually are matters that are attendant to or pertinent to the underlying proceeding. What case law tells you that you are entitled to engage in the Florida Rules of Civil Procedure to engage in discovery vis-a-vis an attorney charging lien dispute?
Well, because I have a pending motion for attorney's fees and a charging lien filed, which established my right to appear pro se under individually.
That doesn't tell me what the legal basis is for having a purported right to utilize and avail yourself of the Florida Rules of Civil Procedure discovery procedures in a attorney charging lien claim context.
The rules of procedure apply to an individual. If they have the background and experience, can appear before the court and to ask for discovery, to ask for pleadings, if they're able to do it, or experienced enough to be able to do it, such as myself, that the practices I have, to be able to establish what was basically my claim, that individual claim, my individual right to recover attorney's fees, because the case law that I've read and cited in the brief, I think, in appropriate places, does point out that a discharged attorney is not does not lose his right to recover his attorney's fees he incurred up to the point of discharge. And so this is what we're talking about.
But it wasn't your, but this matter was brought on motion to impose a different charging lien, not yours. So are you making arguments about procedural arguments? What are your issue one in this appeal is regarding procedures that tended to the resolution of a motion to impose a different charging lien. So what do you have to say about that?
Well,
that's where
the
you're
reason, right, I understand your question. The reason that it's important that I and Mr. Brown spoke up is the piece of property that Mr. Mackey's firm is trying to foreclose in Colorado with just the lien is property that would be a part of the estate of the decedent that I could use as a basis to seek recovery of my fees against. And that was the reason. That piece of property is estimated to be in the neighborhood of $140,000 value, and half of that belonged to the former husband, and the other half belongs to the former wife. And the former wife, if the lower court grants my motion for attorney's fees, I would be able to use that then to attach that property. That's the only reason for being connected to this Colorado property, is because it is an asset that's available to satisfy my claim when it's adjudicated, and it's pending before the family law court at this time. And I have contacted the lawyer to represent me, and I proceed with that instead of being involved in any of this. And so I'm prepared to go ahead with that. And the probate judge did enter an order allowing me to do that from the estate. I had filed a claim in the estate to protect my claims under I read a claim under it's what is it, 90 days statute of limitations, there's a statute of limitation issue there that I have to file the claim in the family estate to protect my rights to proceed in the family law.
Mr. Marshall, you have one more minute.
Lastly, I would say that there's no evidence in Judge Browning's order other than at play. The term at play was used, and that's not evidence that there's protection, preserving, or creating that asset. This is an example that when you don't have the proof, then you try to find out a way to avoid having to go to show the proof. And we're simply saying, Mackey's law firm has to show proof to be able to substantiate that order. And there's no proof shown in the order. Therefore, that two cases in Florida and fourth district should apply. Thank you.
Thank you. I'll go to Ms. Serrano.
Morning, Your Honors. Again, may it please the court, my name is Megan Serrano. I represent Derek J. Hadley, who is the personal representative in the estate of Tom Brown Jr., who is the former husband in the underlying dissolution proceedings. I am here before the court somewhat hampered in that obviously I was not involved in the underlying dissolution proceedings. And as I stand before you today, circumstances have changed somewhat given that Mr. Brown passed away in August of 2021. Mr. Brown initially filed his initial brief, apparently with the assistance of Mr. Marshall. I do not believe that Mr. Marshall's arguments in that brief concerning jurisdiction or due process are well-founded or supported. However, I do think that the arguments, some of which are included in the appellant's initial brief and some of which have been advanced by Ms. Griffin on behalf of the former wife, do have merit. Namely, that the Mackey Law Group, in the 17 months that it represented the former husband, did not procure any judgment or any award to which its purported charging lien could attach. And the Dumel case appears to be clearly on point for this position. In Dumel, the court held that a charging lien can attach to an equitable distribution awarded in a dissolution action. And here, the Colorado property, which is the subject of this discussion and is where the charging lien purports to attach, was part of the equitable distribution. However, the Mackey Law Group played no part in the trial court's determination, Your Honor.
It's actually, it's okay, but would you agree that if that were presumed to be true, that would differentiate this scenario from the Dumel case in which the court made mention several times of the admission by the attorney seeking the lien that he or she did not play any part in the litigation of equitable distribution?
I think the distinguishing factor in Dumel as opposed to this case is at the time that the equitable distribution was awarded, the Mackey Law Group had withdrawn some 6 years ago. And as I understand it, that is not the timing in the Dumel case, meaning that the attorneys in Dumel who were seeking the charging lien still represented the party at the time when the equitable distribution was made. So given the differentiation in timing, I think it's hard to make.
So you think that this court in Dumel, the decision turned on timing of representation as opposed to the substance of the representation?
I think it's hard to glean exactly what were the determining factors. And again, it's difficult to present this court with an argument with so little findings from the trial court.
Now, does that also present a further problem for us? Because there were findings, there's certainly a lot of reasoning, explication by the part of the trial court on its rationale for why it considered the property disputes of the labor of the law firm, but there was no hearing transcript.
Correct.
So we don't know what findings. And I'm going to do the two-part question. I apologize. Is that a problem? And also, do you have an opinion on what is the actual standard of review here? Different standard than bandied about, due process, but isn't a determination made that turns in part on what a law firm did, isn't that determination one that at least is in part factual?
Absolutely, Your Honor. Again, that's an area where we're significantly hampered by not having a transcript. I'm standing before you in the shoes of the appellant, and obviously it's our verdict to bring one forward. Unfortunately, that's not something that we can do in this case, and we have been hampered by it. Which brings in the second issue, which is what I believe is an error regarding the determination of the amount of the lien. There is no transcript of the hearing. And there's no clear indication that the trial court actually heard evidence and determined that the amount of the attorney's fees which comprised the lien were supported by evidence and were reasonable under the factors that are laid out in the Roe case. Instead, it appears that the trial court apparently accepted an amount which had been referenced as an approximation in some of the Mackey Law Group's prior filings. Again, we're severely hampered by not having a transcript to review, but turning back to your original question, I do believe that the DeMel case stands for the proposition that it's a de novo review. So if this is a situation where this court is tasked with making a de novo review and there's an error which appears on the face of the judgment or the order which is on appeal, it can reverse, and I submit that that is what the court should do here, because there is insufficient findings in that order to support the order that was ultimately entered.
That case does mention de novo review. Are you familiar with other cases that assign to this issue a different standard review? I am based on research.
Not off the top of my head, Your Honor, and clearly you've done your research.
Go ahead.
Thank you, Your Honor. Since the Mackey Law Group did not procure the result in the form of the equitable distribution, it's not a fruit of the labor to which this charging can attach, and this is an error of law that's apparent on the face of the order, as well as the subsequent orders upon which that initial order was based. So for that reason, it's the position of the personal representative that the orders on appeal for today should.
Now there's case law that goes the other way. You want to address that talks about, and it's a little older. Let me make sure I'm referring to the correct case. Is it Dyer? Talks about that similar to the rationale expressed by the trial court, which is that the labor itself is preserving assets, not necessarily procuring assets in which prior to the proceedings, the client had no interest, but because it's equitable distribution, and there's no way to, at the outset, be sure of whether an asset owned by the party will remain owned by the party at the end of the game. It can't be said that the players in the game didn't, produce a fruit merely because the asset didn't change hands.
Understood, Your Honor. Again, I think this is a situation where the circumstances are such that more would be required by way of a factual determination at an evidentiary hearing to confirm that that is what in fact occurred. Again, in my somewhat hampered position of looking at this as a situation where the law firm that is requesting the charging lien had withdrawn 6 years prior to which the supposed fruits of this labor were eventually obtained, it's difficult to imagine a scenario where the work that they did could be considered, whereby the equitable distribution could be considered a fruit of that labor. That is what the court concluded, and there was reasoning, but little by way of evidence to make that determination. And that's why it's our position that on the face of this order, reversal is appropriate.
So if we were to reverse, we'd have to write a rationale, and the rationale you're proposing, and I don't want to put words in your mouth, but it seems multiple. One is that at the time of final judgment or the total resolution of the case was attained, the counsel seeking imposition of charging lien was no longer counsel of record. That's one factor perhaps, and also the passage of time since that law firm or lawyer had been retained, or, you know, was no longer retained. But could there not be scenarios in which that a law firm or lawyer, during the time that they had been retained and were working on behalf of the client, did procure a benefit, and then subsequent counsel had nothing to do with that aspect of the case?
Certainly.
That's so, right? So given the record we have, how can we foreclose that possibility, that that's possible? And given the order that we have, explaining the rationale, how can we foreclose the possibility that Mackey Law Group played a significant part in the maintenance of the ownership of the Colorado property, and weighed against whatever part the subsequent firm or lawyer contributed, or no lawyer? How can we discount that? And how do we write an opinion expressing the rule of law and the rationale?
I think that the directive here, which might address your Honor's concern about being consistent with the Dyer case and the cases that came after it, like Dumel, would specify that such findings need to be specific in order to be upheld on appeal. And that's not what we have here. So in requesting reversal, we're asking that this go back to the trial court who can make appropriate findings. I don't see that there's enough for this court in terms of the record to be able to address that possibility, as Your Honor has addressed it, that's pretty much squarely the issue.
And then allow the burden of concede was the attorneys in the trial court, isn't it your burden on appeal to make apparent on the face of the record error that we need to correct?
It does, Your Honor, and our position looking at this now is that it's an error by omission. There aren't sufficient findings to find that the Colorado property was a fruit of the labor. And there's certainly other kind of circumstantial evidence from the record that would suggest that Mackey Law Group did little by way of procuring that as a fruit of its labor for its client.
Mr. Rono, why? I mean, and the reason I'm asking that question, why should this court fashion a rule that says, imposes some kind of heightened factual finding requirements on charging liens in general, when courts have already imposed quite a number of onerous burdens on family law judges and statutes to include detailed factual findings already? You know, this could just as easily, this kind of the heightened factual finding requirement, they're like weeds. I mean, they could just keep spreading and spreading, and we as an appellate court can start laying down rules. You know what? Every single motion to dismiss, you need to lay out findings as you raise every single discovery hearing. I'm sure civil lawyers would love to see that. You need to lay out factual findings as to why you're not giving discovery or why you are ordering discovery. Why should this be treated different?
Well, unfortunately, we don't have a Florida statute which outlines what's required for charging liens. As a litigant, I think that might be helpful and might alleviate some of the concerns that the court has, but unfortunately we don't. We do have very specific rules about what is required for orders where attorney's fees are awarded. That's a very consistent finding. We have very specific requirements for what is required for a lien, particularly one that attaches to property. It has to be specific, it has to correctly describe the property, etc. This is kind of the charging lien that we're talking about is basically an amalgamation of different rules where there's already that very heightened standard. So making clear that the standard is not lessened and is in fact heightened because it brings all of those other things into play, I think is consistent with all the other points of law that have been brought in. Thank you, Your Honor.
Thank you. Why don't we hear from Ms. Griffin next?
Hey, please, the court. Madeline Griffin, I represent Jamie Snyder, who is the former wife of the decedent Tom Brown and the mother of the personal representative. There's 3 children that have lost their father. Derek Headley is an adult, and there are 2 minor children that remain that are that live with my client, and the dynamics of this whole case and the appeal have changed drastically. but I did represent Ms. Brown Snyder in the final judgment that we had, which resulted in the amended final judgment on March 21st of 2016. In the amended final judgment, Judge Nicholas ordered in paragraph 7 that on page 16 of 18 of the underlying judgment, that the Colorado property would either be sold and equally divided with the net proceeds between the decedent and my client, or the former wife would buy out the former husband and he would convey his interest to the former wife and put a value of that Colorado property at $133,000. This Colorado property is not property that is in Aspen or Vail. It's in a very remote, depressed market. And my client tells me that there's a Walmart and a prison, and the people that work at Walmart or at the prison don't have money to buy a vacant lot and build a house in this part of Colorado. So we tried to get Mr. Brown, the decedent, to sign a listing agreement. There was a hearing on the priority of the charging lien that was, an order was entered on May 2nd of 2016. And that determined the priority of the Mackey Law Group's charging lien over Ernest Marshall's charging lien. The motion that the Mackey Law Group filed that resulted in this May 2nd order was titled,
Motion to determine prejudgment interest and entry of final order on attorney charging lien, is that the one?
No, Your Honor, the original motion that resulted in the priority claim that Judge Bruning relied on, their motion was called Mackey Law Group's motion to determine priority of charging lien. And that's what was my argument at this hearing, that I really don't have a dog in the fight, but I knew what happened because we were there and there was not a hearing on the reasonableness of the fee. Mr. Brown was still alive at the time that we went to the hearing that we're here on appeal, but he did not have an attorney present at that hearing, and the issue was over priority, but also contained in the order of the May 2nd order. The order is called Order Determining Priority of Mackey Law Group's Charging Lien. And it, on the ordered in a judge section of that, it states, number 1, Mackey Law Group PA's charging lien in the amount of $10,978.41 has priority over Marshall's charging lien. Mackey Law Group shall be paid first from the equitable distribution that Tom Brown is to receive pursuant to the above styled March 21st, 2016 amended final judgment, whether it be in personal property, real property, cash, or otherwise. And the court reserved jurisdiction for the enforcement of that order. That was entered by Judge Nicholas on May 2nd of 2016. That was just a couple of months after the March 21st final judgment. And when he's referring to the other provisions of the final judgment, in paragraph 10 of the amended final judgment, Judge Nicholas said, and this is on page 18 of the amended final judgment, the court reserves jurisdiction over each party's claim to attorney's fees, costs, and suit money. Both parties had, the decedent and my client had claims against each other. In paragraph 9, it says that the court reserves jurisdiction over any and all issues concerning attorneys' charging liens in this case. And he had that in there because they hadn't been resolved, and that's what he was supposed to do, is do a reservation about a judgment of a final judgment on the Mackey Law Group's charging lien, because they would be first. And that was already decided in the subsequent order that was entered on May 2nd. Then there was yet another order that was dated June 14th that the court ordered that the proceeds from the Colorado property had to be deposited into the court registry in Manatee County so that these issues of the competing charging liens would be resolved. And so there was a remedy rather than a foreclosure of this undivided 1/2 interest that the estate now owns, and the children would have their rights to the family allowance and all the other things that go along with what happens when their father died. The remedy was to, when the property sold, that Mr. Brown's 1/2 proceeds go into the court registry. We've been trying to do that for a very long time. And so
It's been a while since I looked this. Don't foreclosure proceedings proceed outside of probate proceedings?
Judge, this is in Colorado, so there's a case in Colorado, there's a troop of Colorado lawyers. All we want to do, we're trying to, well, Ms. Rano, I believe, is trying to open an ancillary on behalf of Derek to open an estate there, get an appraisal or have an appraisal and try to buy out the estate's interest in this property rather than going through this appraisal. We haven't been able to work that out. But we just want to put the money in the court registry the way Florida has ordered previously and not have this 3-ring circus in Colorado and here and everybody just trying to figure out it's been a conundrum for a 1.5 years.
Would it be accurate to say that the former wife, and if this isn't in the record, tell me, that doesn't have an interest in possessing the property?
Her interest, right now, she would like to buy out the former husband's interest and put the money in the registry of the court. That's what we're trying to do.
Okay.
And Mr. Mackey's got a priority claim over Mr. Marshall, and it will get resolved. They'll get paid, whatever needs to be done. But it shouldn't be, bless you, sir, it shouldn't be in this final judgment that is attaching Colorado property, because that's not what 2 prior orders said. There was a method in Florida in the first order, and I believe it's reversible error for the subsequent judge to disregard that the money should be paid into the registry of the court in Florida and let the Florida courts deal with it. And now we have the death, so we've got to get another court in the probate court. But I respectfully ask the court to reverse the order and to proceed with the charging lien the way the courts in Florida initially intended. Thank you.
Thank you. All right, Mr. Martinez, you have the floor.
Good morning, Your Honors, and may it please the court. My name is Jorge Martinez, and I represent Mackey Law Group in this appeal. They are the appellees in this case. There's a lot of argument concerning this new 2021 final judgment, but really the core issue is the language and the plain reading of the 2016 order determining priority of Mackey Law Group's charging. That order is clear and unambiguous. It states, and it's on page 34 of the record, Mackey Law Group's PA's charging lien in the amount of $10,978.41 has priority over Attorney Marshall's charging lien. Mackey Law Group shall first be paid from the equitable distribution that Tom Brown is to receive pursuant to the above style March 21st, 2016 amended final judgment of dissolution of marriage, whether it be personal property, real property, cash, or otherwise. The court reserves jurisdiction for the enforcement of this order, not any other issues, not to determine amounts, not to determine anything, the enforcement. The language is clear.
How do you enforce a charging lien without liquidating an amount?
Well, the amount is established in this order, the $10,978.
And doesn't this go back to kind of what we're hearing on the periphery that, hey, how did you come up with this? Did they just give you a bill and you said, okay, that sounds good to me?
the unfortunate reality of this issue is that there is no transcript provided about what exactly occurred at this hearing. That's really the central issue of this case.
Did either hear you?
I'm sorry, no, at the 2016 hearing, excuse me. And the trial court in 2021, in an abundance of caution, tried to correct any possibility that this issue was not previously addressed.
So let me unpack, because I've got an issue that I'd like you to, maybe you can assuage my concern on
Sure.
this. So reading the February 2021 order, which you're telling me is basically the court kind of providing some backfill, if you will, for what may not have been established 5 years prior. The court seems to state almost categorically that, well, since this property was listed as an asset in a marital asset, in the underlying dissolution proceeding, and the former husband got his half, it was quote unquote, I'm using court's word, in play, and therefore the Mackey Law Group, which had a stake or had a piece, some part to play when this proceeding first got going, is entitled ipso facto to a charging lien on that. Here's my concern with that. By the lights of that reasoning, every listed asset in a dissolution of marriage proceeding, every one is potentially quote unquote in play. If it's listed as a marital asset, it has a presumption of being equally divided. So the in play actually doesn't mean that it's anybody's game. It means that there's a presumption that has to be overcome, that you're not going to get half. You're going to get less or you're going to get more. Every single asset then, by the lights of the court's logic here, becomes in play. An attorney potentially gets a charging lien on it. How is that any different than a quote unquote general judgment lien that the law says a charging lien cannot be?
I see where the court is going with this, and I don't agree that the trial level judge made that broad of an interpretation in its ruling. So I believe the case law does say that property that the charging lien attaches to must be specific and that cannot be outside the scope of the dissolution proceeding. So for example, if the former husband had non-marital assets or non-marital property, or property that had nothing to do with the dissolution of marriage proceeding, it would be improper to attach our charging lien to those assets since they are outside the scope of what was being litigated in the underlying dissolution of marriage.
And I guess that comes to the point though, it wasn't litigated. You have, the parties in a dissolution of marriage proceeding have to list their property, whether it's marital, whether it's non-marital, but they have to list it all. And a great deal of it in most dissolution of marriage cases is marital. So it seems to me that in effect, what the court's reasoning here amounts to is a general judgment lien on property in a family law proceeding.
I don't agree, primarily because first, again, the 2016 order, in my opinion, specifically identifies property that is to be received by the former husband and procured as part of this dissolution of marriage proceeding.
Right, and what I'm saying is that the defining the term in that way casts a net so wide, it's going to capture all the property.
Sure, and this is what the court did in the.
Non-marital property is usually more the
Right.
exception than it is the general rule in dissolution of marriage cases.
And the trial court, again, in 2021, put Mr. Tom Brown on the stand and did ask several questions. They asked about Mackey Law Group's role, in the representation, and that is on page 300 of the record. And during Mr. Tom Brown's testimony, Mr. Brown does testify that that was an asset that was discussed with Mackey Law Group, and that was an asset that was eventually recovered by Mr. Tom Brown. There was only ever the Colorado property, concerning this issue. So I see what you're saying as to.
I'll give a counterfactual. I could understand if he had listed this as or if somebody had listed this, if she had listed this as marital, and he said, no, it's non-marital, it's all mine. And he ends up with all, I get it then, because clearly, yeah, I mean, there was a you got it off of the bubble. But because it's a dissolution of marriage proceeding, we're talking about a list, what he listed as marital property. The presumption is going to be it's going to be split half and half. I'm failing to see how this order, the February 2021, tells us really what was done that that wasn't going to automatically happen.
I believe the Dyer case on that point is instructive. Basically, the arguments raised by appellants in this case state that because it's marital property, it's assumed that it's going to be received by one or both parties. So in a situation where all the property that exists as part of the dissolution of marriage action is joint property, under the arguments put forward in Dyer, you would not be able to recover any of those assets because they were presumed to be ultimately awarded anyway. But the Dyer case specifically says that that is too narrow a review, and it says that it is not necessarily indicative that the party will eventually receive certain property, because then attorneys in dissolution of marriage proceedings will be essentially useless because parties are going to get and keep what they
Do
already
we have
have.
anything in the record that tells us that that was a litigated issue as to who would take possession of the property? Like, we're not talking about a marital home, because you're right. I mean,
Right.
marital home is often, it's listed as marital property, but who takes possession of that, hotly litigated. And then you've got to true up between what the value of the home is, what the 50-50 is, and offset it and all that fun stuff. But I'm not sure that's really the case here. This is non-state, non-marital property. It's really just kind of an asset that happens to be in the form of real property that sounds like what everybody's arguing over is who gets what money from.
Correct, and at the trial level, and this is on page 301 and 302 of the transcript of the hearing, Mr. Brown does say, the thing I really have an objection with is the 18% put on top of the fees, because I don't think I feel I should get penalized for somebody not selling the property back in 2016. So he's specifically identifying that back in 2016, there was an understanding that this property was going to be sold, and he himself understood that the proceeds of the charging lien were going to be satisfied from the sale of the Colorado property. He goes further to say, if the property would have been sold, like I sold the paperwork, I don't think I should get penalized for having to pay it because I did my job. Somebody else didn't do their job. So again, we're limited by the lack of records in this case. And I think that the issue that you're raising is an issue that should have been, it may have actually been raised at the 2016 hearing, but we don't know. We don't know what was discussed. We don't know if testimony was presented as to the amount of the charging lien. We don't know if it was stipulated by the parties in the court. We simply do not know. And that is really outside the scope of what I believe the appeal before us today is. Because this was not an issue brought forward by Mr. Brown himself at this 2021 hearing. And it's not an issue that was at any time brought forth before until this appeal. So we believe that the Dyer case is very on point as to what we're trying to do. The other case cited by the appellants, the Dumal case, doesn't really apply to our situation here. In Dumal, the attorney repeatedly testified that his role in the representation was limited in scope. There is no record or evidence or anywhere in this case that Mackie Lager's representation was limited in scope in any way, shape, or form. On the contrary, again, the transcript, there's plenty of testimony to support the trial court's 2021 order to support the finding that Mackie Lager was involved at every facet of this case. Mr. Brown was testified as to that point. Further, Mr. Brown does say that on page 295 of the record, that it was his understanding that the 2016 hearing was for the establishment of a charging. So again, these are issues that we believe were already litigated once. In an abundance of caution, the trial court decided to kind of re-litigate some of these issues in 2021. And now appellants are seeking to relitigate these issues a third time by trying to go back to the drawing board. And we don't think that's correct. So for your honors, I believe that concludes my argument.
I asked counsel for the estate, excuse me, I asked counsel for the estate about the standard review, and she understandably, for very understandable reasons, asserted UML is the proper authority, because in that case, the court said it was a de novo. That court cited a case that was actually cited, that actually cited a de novo standard review to a jurisdictional issue, if I recall correctly. Do you have an opinion on that? What the standard of review is here?
I believe it's de novo. Unfortunately, some of these issues are intermixed. The trial court did cite in its in its order in 2021, they did review the entire record, heard the testimony of the parties, and then they did take testimony. So I'm not quite sure if that same standard would apply to the parts of the case where the court did take testimony, because this was an evidentiary hearing and the trial court was in the best position to hear some of these issues at the 2021 hearing. And that is an advantage that the appellate court does not have today. So again, I could not find any case law specifically to support a different standard of review, but I do believe that it might be mixed. But I would stand by the position that it's de novo.
Thank you.
Thank you, Your Honor.
Thank you. All right. As I said, it was a short docket this morning, so with that, we are adjourned. Thank you all. Have a great rest of the week.
Thank you, Your Honor.
All rise.